I'm Judge Douglas Harkin. I'm a district court judge. And district court judges in Montana are the judges that handle, among other things that of interest to you, are domestic relations cases. And if you go in for a temporary protective order, some sort, I would not usually be the judge that you would see. I see the cases when they arrive for a dissolution of marriage. I do child custody cases, child visitation, and generally approve child support orders. And in Montana, you do not have a jury when you have a divorce. You have a judge-only case. That's what they call that. And I'm the judge, one of the 4 judges in Missoula that decide your divorce case.
I'm Sarah Lipscomb. I work with the University of Montana, and I direct a program that provides guardian ad litem services for children whose parents are undergoing dissolution or custody actions in western Montana. A guardian ad litem is a person, the literal translation of that term is the child's representative in court. And my job is to do some evaluation, some information gathering, and then present that information independently to the district court judges to appear at all proceedings in the course of a dissolution and to represent the best interests of the child.
Hi, and I'm Art Brown. I'm from the Division of Child Family Services. I'm intake supervisor. How are you? Can you hear me? I think I'm catching a cold. I'm intake supervisor, which means that our unit is the one that takes referrals of child abuse. And our unit also does initial investigation. And if need be, then we also initiate the program.
My name is Klaus City. I'm the managing attorney of the Missoula office of Montana Legal Services Association. In my office, we represent people in family law cases. Fortunately, the last 15 years, the only types of cases we've been able to handle have been the spousal abuse cases, where there's some sort of family violence involved. As a result of the fact that there's violence involved, we're taking the most difficult of the difficult cases, and as a result, we end up taking more time, which of course means you can service fewer and fewer people. There are about 30,000 eligible clients in our service area for Missoula. Assume there's probably 2.5 people per household. That's at least over 10,000 eligible households. I have 3 attorneys to represent all of those households that call in. So again, we triage a lot of our cases and have difficult times as a result before we ask for our service.
Can you tell us a little bit about your group so we can then maybe direct some of our comments to subjects of interest in that?
Parents Anonymous is a support group for parents who are looking for better ways to discipline their children, alternative methods of raising children other than spanking or perhaps the methods that they had learned when they grew up. Some of the people that come there are involved with the court system, some are not. We talk a lot about child awareness skills and basic parenting skills, and that is the focus of the group, is to support each other in learning new skills and new, better ways of being a parent. But some of the support group also involves talking about the system.
Restricted only to our jobs, or can we brag about little techniques we have personally?
Sure.
One of the techniques that I have found has been really successful with my natural kids and 2-step kids is what we call the red book, which is the book of hell. And in the red book, is the fine book. Fine. And this is where their allowance goes in, and this is where they get fined. And everything they do is recorded in the red book, like when they get older, they're late coming home, they're start from a real early age would always remember the red book. So like their allowance goes in the red book and they learn debits and credits and balances. And it's real easy for me when they like don't do a job, say, well, that little caper, that little lipping off cost you $2. And I go over and write it in the red book. And what's really been a great benefit now that my kids are gone is to look back at this red book as a history. And I can see in there as it gradually was like, hit brother, $1 fine, or did not make bed, 50-cent fine. And then gradually worked up through high school, and then they finished high school, it was something like came home, alcohol on breath, $20 fine, and things like that. And it's just, they go back and it's been a real kick to look at those things as they grew up. And it keeps everybody honest as far as allowances and jobs and rewards and punishments. We call it the red book, but a great asset to our family.
I like that idea.
It's an instrument that is far greater than just a little, account book. It's the great equalizer. Like, I don't do this, it's not for me, it's the red book requires that you get fined, buddy, so that's it.
Okay, supposing a person does spank his child, which is not against the law, is it? All right, why does the DFS take the child away from the parent? It's not easy then.
What do they take a child away from spank the child?
Yes.
Well, I can answer generally. The only way DFS can remove the child is if they feel the child is in danger. And we could make that determination and remove that child after 48 hours while we investigate the situation. After that point, in order to continue to have the child outside the home, we either have to petition the court for temporary investigative authority, excuse me, or we have to have a penalty to keep that child outside. But, like the judge said, it is not against the law to spank the child. It is, we can substantiate physical abuse if there's physical injury to the child, which is different than spanking.
That's true, but I've known cases where you take the child and spank.
That the child just been spanked.
It's because they've been spanked. No bruises on the bottom.
I could, again, it's hard to answer that because every case is different. But again, we could remove that child if we felt the child is at some kind of risk.
But we have kids all the time.
But that couldn't involve more than 48 hours of some kind of legal action.
I think it would probably be safe to say that they would rarely, I've never known them to ever remove a child with one incident of minor spanking. And maybe we ought to distinguish between minor and major spanking. What they try to do is look at all the circumstances involved in the family and see if the spanking that was reported is indicative of some greater problem. You have alcohol abuse or drug abuse or some other factors that say this is just the tip of the iceberg, and or the beginning of a slippery slide down through some abuse of the child. That, I think, is the standard they ordinarily use.
This happened 3 years ago and it's been over and done with. But my son was taken away because of a lie and my spouse's past history as a child. He was taken away for 6 months. They never investigated. We were never offered an attorney. When we come back, they always says, oops, we're sorry, it was a mistake. That's it. I had my son gone to the baby for 6 months because of my life. And they didn't do anything about it. They didn't care about our rights. I had no rights. said, Mother, I had never known. Nobody would help me.
Well, I never said who's. And I've been there for years. I've seen a lot of cases. I wouldn't accept who's either, so I find it hard to believe that the state would have a child for 6 months.
There was no
Without-
sign of abuse. You told me that when I found out that there was no sign of abuse or neglect. There was nothing wrong in our household. There was nothing going on. And I have to share.
This is a little out of my field, but I have some familiarity and possibly jump in and part with the new regulations that make it a bill passed in the last legislative session, which makes it I believe it's a crime to induce a child to tell a lie or to go to the department with a bold-faced lie in an attempt to get somebody else. And that did pass, and that was signed by the governor. So there is some, I can't, and again, I'm outside the area in which I typically work, but the idea that somebody can go in and lie and they just have this total blanket immunity is no longer.
Well, this did happen 3 years ago.
Well,
And maybe everything's down with the pain's still there.
Sure, the thing is that.
There will always, actually it's 4 years ago now.
Yeah, but that maybe you can take some comfort in knowing that the law has been
I
changed,
know.
that it was changed. There's also some other things that came about, my understanding, in the last legislative session along those lines. One is that if a child is placed in foster care, the department must first attempt to place the child in a relative. That's
See, they never informed me anything. They never informed me that we had anybody. They came in my home and took him without asking, not asking, without even looking.
right. Okay, I guess what I'm trying to give you is some information on where my understanding of the department is now. Second is that if somebody calls up and it's a bold-faced lie and the allegation is what they call unfounded, which means there's no reason to believe that it ever occurred, that somebody may be out to get someone else, that allegation has to be destroyed. You can't keep a record of it. I work in divorce cases, and one of the reason I think that's such an important regulation, kind of regulation for the department, and again, that one was went through the state legislature, passed both houses, and was signed by the governor, is that in divorce cases, one of the things that I need to check is I need to check for abuse. And I went in one time to check, and the 7 parents had turned each other in 12 times, all of them unfounded. But there were this 12-page record on each parent, because one of them get mad and they go run and turn the other one in, and this record that says unfounded, no reason to believe, nothing happened, etc. But still, there was this 24-page file on this poor little kid who was 5 years old. So now those records, I think it's 30 days, isn't it?
But he still has a file that lists all this.
Okay, I'm talking about unfounded allegations, all right? That's different than what you're, a little bit different than what you're talking about. But I know that there have been some reforms in the system.
Are you as an officer of the court also have to abide by those? Like, say you would go in and say, gee, mom really doesn't make any sense to the dad, that all and you chose to back up some of the complaints and assisted in having the child removed.
I don't ever make that decision. That is a province of the Department of Family Services. If there are allegations or abuse and neglect in a divorce case, I either have a social worker at my office or I make sure that the allegation goes to the department. But I don't ever attempt to make that determination as to whether a child is being abused or not.
So you don't have the power to make recommendations, but you think,
As far as
where, like, to the court, like, you think that the child should go through this?
Oh, that's part of-
recommend.
That's, in a divorce case, that's part of the duties as they're outlined in the statute for me, is to make recommendations. That's one of the things that I'm supposed to do. So in a divorce or custody case, yes, I do. In a child abuse or neglect case, absolutely not. That's outside the
the child is taken, where do they place the kid? I think if it's a weekend and it's an emergency situation, like a police road or something, the child, if there's an opening, usually goes to one of the shelters. If we have more time, probably the hospital. We have lots of homes that the emergency places will take care of it.
Or isn't it common basic living with
Family.
their family?
And then we do that. Again, like I say, on the weekend, we're also required to check out the family members, do what we call a CPS check, Child Protective Services check, which means that we check the family members, see if there's a history there.
How is that?
Well, if it's during the week, matter, that's really, if the person's from various states, it may take longer because the person has to make a response from other states. But, so that happens quite a bit, and like Sarah said, we're really under the onus to try to change it. And I won't say it doesn't even happen, because I've been called out for like a car, and mother's intoxicated or got picked up or something as a child. Call a grandparent or something like that.
Does your investigating officers have the right to say that you will not have that grandchild?
I
Because
think we
you're
have
in a
to,
different county?
no, that wouldn't be very legal. I think
That's the
the
reason I was
investigative social worker has the right to tell them not to place them for good reason. But being out of county, again, that again is an individual thing, but one of the things for placement, we have to verify is that, for instance, the child's in school, and that's, we want that continuity, et cetera, that might be discussed with the grandparent. But there should be no reason just to rule the grandparent on his own.
How do you fight that?
Call the supervisor.
On vindictive turn-ins by your ex, how many times do they have to do this before a guy will, or I should say, the law will allow you to recourse back at this?
The question is, if there's reports from your ex-partner, how many times do we have to investigate that?
Yep.
Basically every time.
When will they, at the same time, when will they release their names to where you can have recourse to go back at it?
Right now, we can't. The reporter's name is confidential. Does that answer your question? Or not the way you want it?
Well, I think his question is more real timely now if we have this new law that says that if there are false allegations, you can do something about a false allegation, the law that she just mentioned, the new law. So how do you find out who is the false alleger if you have to keep it secret?
And I think that's a real, it's a tough practical kind of thing, because if we investigate and it's just unsubstantiated, which means that we can't show proof one way or the other, then it's still not unfounded. And unfounded means that we can absolutely show that there was no truth to the report. So what the judge is saying is very good, that in practicality, since that law has been in effect, there's been a few cases, but far and few between where you really can show that.
So it's a catch-22 law.
Well, I think it's really good that it's there, because, you know, it does.
Well, if the accuser knows he is to get told on, or she is to get told on,
Well,
sense of having the law. It's right back to where you started from.
But if there's, for instance, if it's the same recorder, and let's say it's a mess, and there's custody things going on, and we can show it's unfounded, which does happen, we also can substantiate emotional abuse on that part. So the recorder, quotation on this law, could have action as a part of it, contrary in the past, that probably could have happened. Because oftentimes the child is caught in between those records.
But you're right, you've got a real good point, is that what good's a law that says that you can sue someone who makes a false report when you can't find out the name of the person who made the false report? So,
At least confidentiality laws for what you're doing, because that's what DFS guy, you know, has to tell us. It's not.
Well, you know, there's, personally, I think there's a way to go, and I think legally they're right now, but that's the way it is.
I think part of the problem that we see in the confidentiality laws is that the confidentiality is mandated, is federally mandated, and the law that we're talking about that allows you to substantiate emotional abuse against the ex continues to put the child in the middle as a state law, and they didn't make the two match. They didn't make the federal law, which came down with the mandatory reporting and all of that. In the 70s, match with the current law that was just passed by the state legislature and signed by the governor. And so there's this discrepancy between, and maybe the judge can better address the discrepancy between state and federal law.
you hope the federal law will change, because the problem is that they have priority, and we have to follow what they say. So, I don't know, I mean, even if you went back to the Montana legislature and said something about if the allegation is unsubstantiated, the name of the person must be disclosed, I imagine that they would say, we'd love to do that, but federal law says we can't. It says the FBI is stronger than the Attorney General's office in Montana, the feds win. And so it's Max Baucus, you gotta talk to the state. That happens all the time.
Everything about your state legislature, about stuff they want to be, can't inform, but they can't do that.
You see, you've done about all you can at the state level by getting this law passed that she talked about. But now you're just smacking into the wall of federal law.
Well, I went to South Boston with you the other day, and I asked him, well, he was busy, of course, put down my name right as a woman, and I said, well, you get that to me. He said, you get a call in a couple of days ago.
Well, let me give you this suggestion. They get a lot of people that complain about this or that, but what they don't often get is someone that points to a specific problem, like we've got a new Montana law that does this sort of thing we talked about, but it runs smack into the federal law, which won't let the Montana law operate. So this is the federal law that we should get changed. I'll point to the specific one about the confidentiality of the informant. And that may get his attention rather than just wanting to talk to him.
Do you have any kind of checks and balance systems or any advice for people who have literally the power over the kids as to where they're going to go, if they're going to go to DFS, if they're going to go in one home or another or off with parental? Is there any kind of checks and balance, like you guys require that none of your staff members have a felony on record or perjury or things like that, where they've never been convicted of those things? Or would they continue to keep their job and be allowed to practice in a position of power over children if that was the case? You too. I mean, I guess I'd like the courts.
Well,
The
I
courts
know,
would not allow
the only,
them.
you know, there is a federal check and a CPS check for state workers and child protection services. That's the two checks and balances. And obviously, anyway, I'm working.
to where it really affected the outcome of the children, where they went, would they be allowed to continue?
I think their career would be finished for good. If it was ever established that they falsified something or they lied about something, they're done.
So they don't have a immunity to that, or,
Nobody has immunity for lying. But just, excuse me, go ahead.
If the DFS tells you something, then when you go to court, they tell the court it's completely different, isn't that right?
It is, but the difficulty is establishing that they said that first thing, and sometimes what you think they said may not be exactly what they said. And like, there's words of art here. Words of art meaning like unsubstantiated complaint is a good example of a word of art. You mentioned that an unsubstantiated complaint is one where, what was it? That's when there's absolutely no basis for it at all.
That's okay.
Unfounded. Yeah. And then, what is it when it's unsubstantiated is that?
Well, I think when the rules are raised, the comments, the evidence says that leading it to one way or the other, but you can't rule it. You rule it out,
And so they may say that, well, we can't rule it out, and it's not, we can't really decide one way or the other, so we're going to drop this whole thing. And then they get in court and they say, well, it's not unfounded. And they're using different terms there that you may have misunderstood. And may sound like they're lying. They told you there was no basis for it. And when they get to court, that's not what they say. They're using different language. But let me answer your question. You talk about checks and balances. He'll bring in a report of allegation of abuse, and oftentimes we'll appoint a guardian ad litem who will check into it. We'll appoint an attorney like Klaus to represent one of the parent, and then I or one of the other judges will look at it. So if she sees something as a guardian that this is bogus, we'll throw it out. And if Klaus comes in with a good argument saying that's not true, we'll throw it out. Or I'll look at the paperwork and say, this is no good, we'll throw it out. So all the way through, we're like, check, 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 check. And there's different people. She owes no allegiance to him. I hardly even know him. And Klaus, he's his own man. He's a lawyer, and he represents who he represents. And so that we're not, it's no conspiracy, left hand, right hand working together to take somebody's kids away.
is there a nice way to phrase perjury? I mean, if somebody, somebody's lying with that on the stand, is
Disingenuous.
that the way to say it? And then it's not punishable?
Or a lion dog, that's a different way.
Misrepresented facts, would that still considered perjury? A deliberate misrepresentation of facts, if it was done on the recording type thing. I mean, is that what you take to prove it?
That's like a social worker.
Or like a guardian ad litem policy, representing facts.
Like the guardian ad litem would say, I went and talked to the lady next door who's a neighbor, and the neighbor lady said, I heard screams coming from that house, when in fact, there's no houses around, so there's no next door neighbor. I mean, that's a lie.
Right.
And, I mean, that kind of situation.
Right, or if that's absolutely, totally a lie. Depending on what reports you have.
I don't know, Mary, I guess, Klaus.
Well, a couple of things. One other check and balance, I haven't done dependency neglect cases, what these are called, for quite a number of years. But when we did them, I know that DFS, would tell me if we still do it, Art, was that even when they had a temporary investigative authority, they had one social worker do that, do the investigation. And then if a temporary investigative authority was ordered, then they would assign another social worker to take over the casework on the case, which I thought was sometimes very confusing, but again, that was the idea to avoid this sort of conspiracy idea against the parties. Now, over the years, all the way back to the late 70s and early 80s, when they rarely go to court on most of those cases that they do in fact seize. The children are eventually returned. Remember, it wasn't too long ago in this county, you guys tell me when it was, that we had a shaken baby that died. And it wasn't too long before that, we had a social worker that was shot. These are the toughest of the tough cases that DFS is taking. There is really no reason that they would want to keep children under those circumstances. We're blessed in Missoula, I think, by having some of the better social workers in the state. If they make a mistake, I've known them to admit their mistakes and been able to correct them. Not always. Sometimes you have to challenge them all the way to the Supreme Court. That's another reason Judge Hartman pointed out that parents are entitled to have appointed. And the children can be represented by attorneys as well when it gets that far in court.
How do you get around your conflict of interest if you get two poor parents like the same child?
Pardon me?
How do you get around your conflict of interest?
Which conflict?
They said they appoint the four people to you, but you got two poor.
No, they don't send me.
Well, said they appoint attorneys. So
Different attorneys, you know, like,
Yeah.
mom gets a lawyer, dad gets a lawyer.
If they don't have the same reason for wanting their child, sure, they get separate lawyers.
if they're both working for Montana Legal Services, isn't that
They don't work for Montana. We don't get appointed to those people.
What they'll do is they'll oftentimes point to the public defender's office, and if there's a conflict, like mom says this, dad says this, we'll appoint the public defender's office to represent mom, and then there are private lawyers in town that will represent dad. They're paid by the state. And I can assure you, lawyers take their obligations seriously about being independent and representing their client, regardless of who pays them. They get real serious about it.
Between me and my ex-wife, she ended up spending $8,000, I ended up paying $3,000, I mean, that I gave her before she did.
I have a question on that matter. About a year and a half ago, I was going to be divorced, and I was trying to custody of the kids. My ex was ordered to pay child support. Well, it's been a year and 4 months since I've seen a dime, and the state's not doing it. I know he has a job. I reported that job to the state. They won't look into it. He has been sitting on a panel with nice cars, nice clothes, everything, but police hardship.
He claims hardship.
Yes. But he's got nice cars and nice clothes and has a job and spending money on booze and whatnot, but won't pay child support. And have the first one to their divorce. For the state. I've called every month for 5 months, they won't do it.
You know, I've noticed an interesting thing in Montana. That's very county specific. Depending on the county you come from, you'll get better results. Some counties are slack on it, and some counties are pretty tough. Missoula's slack on it. But another recourse for you is to hire your own lawyer again and ask your own lawyer to go back to court on your divorce decree and ask that the judge find him in contempt of court for not paying. Contempt of court means jail, and if we bring him back to court and we determine that he is able to pay, but he don't want to, you know, I've got a ton of expenses to take care of, or truck expenses, then we'll just send him to jail for what he pays. It's amazing what kind of money we can get when the person's in jail. They can get money right out of it just by calling on the phone.
Okay, I don't have much money. Is there a place I can go that will help me out with this?
If your case looks good, the lawyer may take it hoping that he will get paid when the case goes to court. Now, ordinarily, you don't get attorney fees awarded in contempt of court cases, but you can if it's part of a divorce case. You can always award attorney fees to the winner in a divorce case. It's basically if the loser, that's him, has been real.
More than one way.
Well, you're the winner, you got rid of it. And so, go back to court and you were able to establish that he could pay and hasn't, then you may be successful getting your fees paid. And their lawyers are willing to take like that.
Can you give me a name about that?
No. I would, but not allowed.
Oh, okay.
Get out the little yellow pages.
Failure to pay child support in this country is a national tragedy. When I started practicing law in 1972, the average child support payment was $68 a month per child. Now, 23 years later, the average child support payment has gone up to $78 per
Even
month
for
per
a
child.
child.
Exactly.
For God's sake, it costs more than that, just the roof over their head.
Less than half of those that are ordered to pay it all, and only a quarter of those that are ordered to pay the full amount. The full amount again, the average is $78 per month per child.
But remember this, every month that goes by, the money he owes builds up. He always owes you that money. And someday, when he's about to sell his house or something, you can make sure that the title company that's handling the sale knows about your lien against him. And you get the money. It's not like gone and vanished. He still owes you that, and it builds up just like money in the bank.
So if he goes to get a loan for something, will they, like if a bank goes to, they do a credit check, do they look at that, do they see that?
It's on the record, it's on file.
So if he goes to loan, the bank looks at it and they look into his, credit history, that's there too.
Mhm.
Better.
So, does he have a house?
He's living in his girlfriend.
Sooner or later, he's going to slip up. Can I give you another parenting suggestion? All right, here's this one. How do you keep your kids from bleeding you dry for clothes? I've got the answer.
Oh, good.
I used to go to the store all the time. Dad, I gotta have this Levi's. Dad, I gotta have these Air Jordan Nike Super Jupiter, whatchamacallit's, $80 a crack or 120. And I'd go in the closet and there'd be like 30 pairs of jeans and all this kind of stuff. So I finally smartened up and put them on a clothing allowance. And I found I paid them too much. That was my only error. But I would give them a certain sum, a couple $100 in the fall for clothes to start school, and then some monthly clothing allowance, $20 or something like that per month. And it was the difference between, and we went in the red book on another. So on September 1st, you'd get $200. And that would, there are usually some mistakes at first because they go out and buy like, $100 worth of Levi's and they forget to buy a winter coat. I'm not buying a winter coat. You got your $200, you got your monthly allowance, and you got your shoes. The difference was night and day when it's their money is buying this stuff, these clothes. My daughter ended up buying, no offense, at the Salvation Army and at the second-hand store, and it fit right in with the grunge look, of course. But you can buy that grunge stuff new. And so she went and bought it all used, and my boys did the same thing. And it cut down more than anything else. It cut down the clothing fights. You don't need it. Yes, I do. No, you don't. Yes, I do. Instead of like this, sure, you can buy what you want. You can buy a pair of leather pants, leather coat, you name it, on my money. And it makes all the difference in the world. And every time, and now when they got into high school, they'd go out and buy something, and they'd say, well, I spent $30 on a pair of stuff, so Dad, I need $30. And I'd say, give me the receipt. You don't get paid back for your clothes unless I see the receipt. I get the receipt, and I pay you money as long as you've got credit in your book for the $30, and I'll give you the $30 that you pay. And just the fight, just cutting down the fights is worth all the hassle of doing it. It's also interesting to see the record change between like Hennessy's, $30, something like this, and then the next thing I see is up at second-hand store, like $30, 5 pairs of pants, 3 shoes. Yeah, kids turned into smart shoppers. They're always looking for a deal, always looking for a deal. So that's my second only good things for hands.
Well, I thought that the one, what do you do when you have a 15-year-old that wants to act 17-year-old? And you know, you
That 15 and what?
15-year-old that wants to act 17-year-old because she hangs around with an older crowd, and the more restrictions you put on her, and my kids don't have an allowance, so that I don't really have to take back from them, or, you know, charge them or fine them, or, I mean, at times. with
Does
the-
she drive?
She lost her privilege for trying to settle over her implementing lack of responsibility.
Driver's license is a real tool. Take that away, so you haven't got a driver's license.
She lost driver's ed. I mean, we were on the right track for a while, but and she, you know, has to take her responsibility in good sense, so she can get hanging over the car and bring it to the other.
So she's got no allowance to take away, she's got no driver's license to take away. She's got bone restrictions. Bone restrictions and things like that, that was good. And you know, sometimes they just go, so what have I got to lose, the hell with you? And then they just totally rebel. And
They go to bad, you know.
that is one of the biggest problems that divorced parents have, is the bad mom, good dad, or the other way around.
I don't know.
Bad
Dad
dad.
will let you do this, I don't know, I mean.
But I guess I would recommend that you stick with your principles and to hell with him, or hell with her, whichever the case may be. You think you do what's right, even though they get spoiled on the other end, you stick with your principles, because that's the worst thing you can do, is be manipulated by some squirt kid. Because the other parent is controlling you. It's like the other parent who you got rid of, you thought, is now reaching down and controlling this kid reaching over and controlling you, and it's really being controlled by the ex-SOB over there. And so, I
They
don't,
go one to the first divorce counselor, they need to be here, they find mom always and it comes out against you. You know, and you say, hey, I don't want to have them in the streets, what can you do that?
you know you're doing the right thing. And you have a tough job, which is to raise that kid in the face of a lot of adversity. It used to be bad enough you were, you know, back on the farm when you had your regular mother and dad there and the kid was complaining about picking rocks. But you had some control. Now you have very little control. With the kid going to the other parent on the weekends and having a good time and being bought off and all the other influences. Being a parent is tough. You know these days.
Did you ever argue with your 15-year-old?
I've got one at home.
Oh.
You want
It just seems like it's typical with parents, they're going to argue,
Well,
especially with 15-year-old.
what do I do when he says, I want to borrow the car? And I say, no, he's my stepson. He says, well, my dad lets me drive the Lexus. I don't even know what a Lexus, I can't even spell it, let alone drive it. So what are you doing? And I'm like, you're not the only one. The rest of us have these problems too. I'm trying to control our kids. You just figure out what you think is right and stick to your guns. No one's going to fault you for saying curfew time. Do your chores. Shut your mouth and be respectful. I should. Yeah, that's one.
Already enlightens you.
I don't think I do. Ask her. Ask her. I said,
I-
do your chores, go to school, keep your mouth shut, be respectful. Ask her if she thinks that's bad.
I've seen it in court. Oh, different. It's different than it is in Penn.
Those particular things that you're mentioning, I don't see as being negative influences on children at all. Children whose parents are undergoing dissolution of custody actions, needs much continuity, consistency. There needs to be some level of communication between parents, both between divorcing parents, in order for children to grow and healthy. Parents need to, to whatever degree they possibly can, agree on consistent rules. partnership, in the partnership of raising children. And that partnership will continue for the rest of their lives. And the sooner that ex-spouses can reach that partnership, the healthier the kids grow.
Let me interpret what she said. She said you should try to reach an agreement with the other parent because kids need stability. More than anything else, they need stability. And the problem is you don't get stability when you say no, and he says, instead of the dad, says yes. You don't have stability. You got a kid ripped apart. Like, what kid wouldn't go for the easy route? That's a given. Like fish go for certain kind of flies. Well, kids go for the easy route. It's the way it is. And that's what makes if you're going to be the tough parent, the hard thing to do. And that's what's tough on kids is you got a tough mom, he's dead. They don't communicate.
So how do you give a kid stability when the parents are stuck in a foster home?
Didn't you cover something?
No, not really.
Or when they bounce back and forth on this new rotational custody. You know, obviously parents don't get along if they're getting divorced. It seems like there'd have to be some kind of a time frame of cooling off and letting the children have one stable place, you know, to live. And then as time goes on and things don't get so bad and parents can agree on consistent rules and things, that would seem to me more logical, but it seems like no way of this rotational custody. I mean, we tried everything in life from month on, month off to, at one point it was going to be a 6-month rotation, then a 4-month rotation. It just seems like when you've got one parent putting their foot down saying, no, you can't do that. Of course they're going to want to be with the other parent, and then they know, hey, all I got to do is just hassle you for 28 more days, and you're out of here and Dad's back. And I'll do as I presented. The real tough, I don't understand that ruling very well. I don't know. Gives parents 50-50 time. And he's very unstable.
It's not always best for the kids to do that. So I think you'd agree the answer, though, is not go with the weaker parent, the weaker being the more permissive parent. You shouldn't go down to the lowest common denominator, which is whichever the weakest parent is, okay, I'll be that weak too, and I'll be that permissive too. Somebody's got to draw the line and be firm about it. And even if it makes you look like a bad parent, unless you can get the kind of cooperation that she mentions, I don't see anything wrong with being a bad parent. Bad in the sense you're a firm parent that requires discipline and responsibility. No one on this group is going to fault you for that. If they do, they'll speak up right now.
Don't be too strict, or the FS will come out on your door.
I don't think I'm too strict.
You also take the children to
They need to be 15 while they're 15. I mean, every little hour, maybe if you want to do some chores, maybe take some responsibility.
My 4-year-old has chores he has to do. He doesn't do them outside. He didn't do it today. But he knows the rules. We have to have his friends, it's a big deal.
That's one of the key things about discipline, I think, is every kid's got his button. And if you playing outside, that's his button. And he may need, fining or extra job, shooting, he doesn't care. Going outside, that's his big thing. You need to find that button. And work on that.
Fortunately, he's young enough, and that's all it is.
I have kind of a different question to ask, and I really don't know who to address it to. My son was just informed he had to take a blood test for DNA, and
For which purpose?
for purpose of proving a child was his.
For the parent?
Right. And this has all taken place, and he is the child's father. The thing that we were really concerned about, the child is now 5 years old. We've never met this child. And we would like to get to know the child. As far as paying the child support, you know, he is the father, this is not a problem. But we would like to get to know the child. We were told that
By whom?
Child Services? Child Services, that if he asked where the child was at, he was told that he could write a letter, they would forward it, but that would be all they would have. This may be wrong, but this doesn't strike me as fair.
Now, wait a minute, they're trying to get child support out of you? So you're gonna pay for a kid that you're not gonna be able to see, or?
Well, I have no choice unless I quit my job, you know?
So my next thing.
No, wait.
Now that, I don't.
Let's get some advice.
And we want to get to know this child. And we realize the child and the mother, you know, should have some protection too, but there's no
What do you mean
hostility
by,
there.
what protection do they need?
Well, I realize certain times there's probably hostility there. And, you know, this is not the case. We would just like to get to know the child. How do we do this without spending thousands on lawyers' fees?
So one of the workers from the department, is the one involved telling you that you can write a letter?
Yes, sir.
So we have the child in placement. The child with the
The
mother?
child's with the mother.
You know what our letter involvement is? I mean, you were asked to get child support through court action. You were named as the father and therefore got the child support.
No, actually, about 7 months ago, I walk into the shop, my boss informs me that they want to take child support out of my paycheck. My jaw hits the floor. I'm like, what? Well, they called him and they wanted me to start paying child support. But first, before I could do that, I had to take a blood test. So they talked to me, they talked to my boss before they even knew the kid was mine.
Who's they?
Child
State.
support enforcement?
Yeah. And once, okay, well, I talked to the lady that day, a lady there, about this. You know, I had no idea. I didn't even know this child existed. I get to hear it from my boss. Well, they say I have to take a blood test, so I go take a blood test. They start sending me papers constantly. Basically just to get more information for them. Well, I've complied with everything that they wanted to this, you know, at this point. I haven't heard anything about how much child support's gonna be. They won't tell me where she's at.
Did they say why they won't?
No, they just said it was confidential.
Well, at this point, you're at a fairly preliminary stage until they send you another document, which is called an administrative ruling.
Well, it's gone to the point where my name's been put on the birth certificate.
Okay, but that's because of the blood test.
Mhm.
But they still have to do the administrative ruling where they run the numbers, your finances and hers, through the computer and come out with the child support amount.
Okay, but they took all these numbers like 4 months ago.
Right. That's not unusual. They're at least 3 to 4 months behind, sometimes more. Then they'll send you an administrative ruling, which on the back of the form will have a right for you to appeal if you disagree with it. That's the opportunity that you'll have to find out the name of the informant, the other side, and then it won't be confidential.
I have this suggestion for you. I think you better get a lawyer. Ask your lawyer to tell the lawyer all these things that you told us, because from what I know, you have every right to see your child. this is, you're paying child support for a child you can't see is outrageous. But as he said, you have got to go through the steps and make sure you're not a danger. She may say he's a dangerous guy, or he's going to run away with the child, or something like this. Well, you can assure him that no, that's going to happen. If you're going to be a father, be a father. See him, visit him, pay child support.
So, but one, in response to what you were saying there, the fact that he pays child support isn't what gives him the right to see his child. It's the fact that he's the child's father.
If you were flat broke, you have the right to see your own natural child. So I think in the long run, you should pay your money to the lawyer and get something going so you can be represented. As long as you're not represented, people aren't going to listen to you very much. So, lawyer girl.
Sure.
Better get in the act before it's too late.
Right.
I'm serious. You get in there while the getting's good, so that you can tell her, as soon as I knew of your existence, I was there. And I'll always be there. You can get going right away.
And Montana is one of the few states, maybe a dozen, maybe 15 states that have full grandparent visitation as well.
And you too can have mandatory, laid down in writing, visitation rights. Even if he gets thrown out, you still have rights to that child.
Would that apply to a foster home?
It's a different story. This is in a situation where a grandparent petitions the court independent of one or both of the parents for visitation rights. There may be times that when you have situations where DFS involved, it's not applicable at all. What I'm gathering here, one thing is that there's a lot of misunderstanding about what the law may or may not say. And while some of it is complicated, it seems to me that most people can make some heads or tails of it. Most of the stuff we're talking about, you find in what is called Title 40, and a bunch of sections after that, there's one for DFS, the Department of Health, and Public Health and Human Services now do this. The Montana, it does not copyright its laws. So if you don't catch the librarian breaking the back of the book, you can go to the copy machine and copy to your heart's content. If you have access to a computer, you can send a disc to the Legislative Council and say, I'd like to have Title 40 on this. And they'll send it back to you in any word processor format you want. And you can print it up and make it fancy or make it look like whatever you want. You can do anything you want with it. That's one of the beauties of not having Montana's law copyrighted. It belongs to the people. People always have access to it. So I encourage you to get a copy of that Title 40 and the chapters 1 through 9 now, I think it is. They have everything from family law in it to child support enforcement. Some of it is going to be minute detail that you don't care about, like how the child support enforcement division works. But on the other hand, it's going to have some useful information to you, for example, on how DFS works, its authority, and how in the family law where a voluntary guardian ad litem is appointed by Sarah.
I have a copy of DFS policy.
The law always overrides the policy.
University law. University of Montana Law Library doesn't write up the city library.
Why is that?
It's not law. The law always overrides the policy.
spells out what DFS is supposed to do.
Doesn't the law library have the administrative regs?
Yeah,
The green book?
some of them, so they're hard to keep up to date.
That's another thing, administrative rules in Montana, that's not law.
Well, it's law unless the law, it's the law unless the law is different. Yeah. Like, say for example, there would be a regulation that says that a social worker has to knock before coming in. Okay? But their regulations say you can enter anytime you want, don't bother to knock. Their regulation is not valid if the law is opposite. The law rules before the regulation, but if the law says DFS can go to the house, and the regulation says if you have a good reason you can go in without knocking, then that's not a conflict, and so the regulation would prevail.
Because I know I went to Larry Ranch here when he was becoming a woman that had a council rights business. And in the ARM, there's a, I can't remember what section, but it says the DFS is supposed to destroy the records after everything is settled and done. There's no substantiated claims and allegations that are not unfounded. They're supposed to destroy those records. And actually, even told me that isn't what the DFS does. I said, well, it's the ARM. I said, well, it's not law. Why would you figure that out? Because it's there.
Well, you know, a lot of things are like that. There's a rule that says that if you get a deferred sentence, postponed sentence in a criminal case, and after you've done your deferred sentence time, in case the charges are dismissed, that's if you were never charged. Well, if you get convicted of a second crime, the judge, when he sentences you on the second time, he can look back and we see that you had this other charge, even though they said it was dismissed and off your record. And we take that into account. So.
I have a question for you, Eric. Exactly what are your like set of standards from what somebody calls in and supposedly like reports like some abuse and neglect to you? What exactly, I mean, contains that, whether it's valid or not valid?
It's a tough one. I guess what we rely on are the social workers' education, probably specific training and interview, et cetera. And I would say, the physical abuse we got with the part of it. But with the others, I would say an awful lot, the majority of it relies on the interview, both the child, the alleged perpetrator, whatever the might was. Probably most of the time, those immediate parties, okay, sometimes, school people might come in or something. So I would have to say, most of the time.
So that is a common practice, for say the child, the children are being interviewed in like a first-hand report of neglect.
Neglect, campus, neglect, it's, let's say it's reported 30 hours or something.
And do you let them know in advance?
Probably not.
That's what I was curious about, exactly what kind of proof would need to be given, like on neglect, because it's so hard to, prove. I'm like in my case, I'm going off what the children are telling me. And I didn't know whether, I didn't think that it was something you could like record and take to somebody or exactly what
Sir,
you're
are you
doing.
saying that would we rely just on the child?
If you knew what was going on, yeah. If I were to say report it, would that child be brought in and actually interviewed for like neglect?
With sexual abuse cases, majority of the time, we will interview the child, but we will also perpetrator.
You have a question?
Yeah. I have a friend whose little girl is 10 years my oldest, who told her mom that her dad was touching her in places that he wasn't supposed to. Well, she's got custody of the kids, he has limitations, blah, blah, blah. The state's not doing anything. And this has been about 3 months since she was brought it up. She's gone to the police, she's gone, she's talked to DFS numerous times. The child has even told the DFS worker and the sheriff what had happened, and nothing happened. He still has full rights to see this child every other weekend, which is when it's been happening.
What do you think this means? He's got pulled. No, seriously, what do you think this means? Do you think this means that DFS, we'll call them DFS, it's easy to name. The DFS says, yeah, there is sexual abuse here, but we're going to let it go on. You think that's what it
They
means?
haven't even contacted him. I don't know who he is, but they haven't even contacted him to investigate it. So it's just sitting there. And I know that she has, she was right in that spot. I haven't heard if she's been, haven't talked to her.
Did they interview the child? Did DFS come?
Yes, and they had a report. You know, she did tell the DFS worker what had happened and showed, by using the doll, showed exactly what happened. Which is really scary when a 4-year-old can do that. But, so the DFS worker believes this little girl. And it's on, it's on file, like the legal said, and the sheriff has a report on it, and they haven't even talked to the father yet.
The DFS would rather take the children that aren't abused, that's why.
Well, I think, I'm not going to, I know you brought it up, but I want to try to one of the difficult things, and I know there might be a couple of things around this, that we are also mandated to protect people that we have no reason to interview or to refer to law enforcement. So, for instance, if the child, unless in such abuse cases the law enforcement involved most of the time, if the child may tell the worker something different than they tell the parent, and that's what we have to go on, and that's where the workers training comes in. But if the child doesn't say it's daddy or the neighbor, we just can't ask law enforcement to go out and interview somebody.
She said who it was.
Well,
Does that mean anything? I mean,
She said it to whom?
she told the DFS worker.
You were there?
No, this is what the mother told me.
Was the mother there for the DFS interview?
Yes. I'm just trying to, get some information to suggest to her to help her out. I mean,
I agree.
Don't give them, keep pressing. And I think you
I'm
both
just trying to be
kids.
her friend and supporting when I can. I mean,
Yeah, I think a lot of times the workers in an interview know that there's something going on with the child sex because they're work, knowing certain body parts, etc. Dirty words for parts that, are the treating environment. But unless the allegation is very specific, sometimes it's,
Keep this in mind. We've heard things from this end of the table about what the hated ex-spouse does. And DFS sees a whole bunch of stuff come in saying, my hated ex-spouse is making these allegations. And then from the other side of the desk is, look what my ex-spouse is doing. So a lot of the times they're wrong on either side. So they have to sort of pick through and see, are these really valid allegations and can we prove them? Because if we start ripping these families apart, as he pointed out, we're destroying the relationship between the father and that girl, but if we don't do something, we're destroying the girl.
this mother has been able to keep her little girl away from him. not being home when he comes by, not answering the door when he comes by. He's been able to dodge it so far. But
I bet we've got a dad in this room that's experienced that same kind of a thing from an ex-spouse who ducks out on him with the kid all the time, and he's mad as hell.
I'm sure. But then also on the other hand, you know, if my child says that if my child says that she's going to use my phone, I do not want him around. I mean, why would I want to send my child back to that? But then again, this father has rights.
That's right. You should check into that, even if the dad isn't doing it. If there's a suspicion of a sexual abuse case, then there should be some interaction right away. It shouldn't matter whether it's, well, maybe, you know, we can't go specific. If this little girl talked about her dad touching her, somebody better be knocking on his door.
Yeah, they should be.
If that were the case, we would.
It was that simple.
If the child told us that Daddy did X, Y, and Z, and we felt she proved that, we would do it.
Well, this child has said to the DMS, yes, but
Yeah,
first.
there were two parts to what he said.
True.
He said that the child said it, and the child is credible. Part one is said it, part two is credible.
How do you determine credibility of a 4-year-old girl?
Say that again.
How would you determine the credibility of a 4-year-old girl? From her past history? She's 4 years old. Why is she going to lie about her dad touching her pieces?
Consistency on interview.
Are you around interview? I know she did interview more than one time.
Are you allowed to have the fixed orders at all interviews with the DFS?
They're not admissible in court. I know.
A lot of, I think Zula said it where at least sexual abuse interview will be on video. I think that's something that.
One thing that's happening in Missoula is a CARES unit is being established in it. And at a CARES unit, it would be a one-stop for the child. So if there's sexual abuse, the child would be taken to the CARES unit and it will have one interviewing process to go through with someone who's trained specifically to do that. It will have one doctor's exam with someone who's specifically trained to do that. It won't have to go through a series of interviews, first with police, then with DFS, then with somebody else. It's going to be a one-stop, and they have CARES units in Great Falls and in other places around the country. And they're very successful, and they usually do have them on videotape, and funding's in place. A couple people working really hard as a committee together, and it'll be a really good thing.
In the interview, it's going to be multi-agencies, like the county attorney and a law enforcement agency.
We can't minimize the seriousness of what you're saying. On the other hand, these are so difficult cases to prove, especially with young children. I'll give you an example. About 5 years ago, a woman comes to me and says that during the custody battle we have, the child goes to the daycare provider and says, "Daddy hurt my baby." When asked with what, with his beard, with his face. Okay, this is a 3-year-old now, almost 4. 2 psychologists examined both mother, father, and others as well. They disagree. 2 social workers absolutely disagree. In fact, they get so angry at each other that one of them quits the offense. It's just a really horrible, and then of course the judge is faced with trying to decide what to do in that situation, not only with the DFS case, but with the custody case as well. And yet, even though he eventually passes the lie detector test, my client, mom, never would have convinced that he didn't do it. But, it's an extremely difficult case, and all you can really do in the court system is use your best judgment to make sure that that child is protected. And in my experience, the court at least cares on the side of protection for the child.
To me, in my experience, it seems as though there's also certain people that can, I don't know how it happens, that's why I was asking what makes it a priority to be investigated, but almost, when they get into that system, it almost works for them. When it seems like the proof is just expounding out to this with my stepson. And I called in that I thought there was a probable sexual abuse problem. And the child had been charged, she was 8 years old, been charged by the state for sexual assault on a 3-year-old. For the purpose of getting that child into counseling. And we called the county attorney, we called youth probation, everything, and nobody would push for this child to get in there, but there was this expounding evidence that there obviously was some kind of problem. But it never had the priority to, we couldn't get anybody to really push it, and that's what I was curious about, what exactly.
So the situation was, another, a child outside that family had abused the child. Is that-
Right, well, he was inside the same family, it was my stepson, my son's father, but, nothing, I mean, the state even got involved and said that they pressed charges for the reason of making sure the child working in some kind of counseling. It's been 2 years, and we've called you probation, everything, and nobody will enforce the child getting in there. To me, that's like an adult molester out on the street, because this child's never gonna get any help. But when you talk to him, he laughs it off, the father, he laughs it off, because I have reported him several times, he's like, well, now I got 3 child here, and there's nothing I've really done to him, you know, to him it's a joke.
I don't know. That I agree, I think sometimes that we, you know, we have pushed the situation just to get.
Thank everybody for coming. Thank you guys for coming.
Great, thank you.
Thank you very much.
Thank you.